Now, the first thing what you have to do is to understand what the Roman law was and why it's sufficient about that. The term that they used was occupatio, loosely translated as occupation. And what they meant by that is that the rules of possession require two things. One, that you actually occupied, that is, took over the particular property. And two, you gave notice to the rest of the world in one form or another so that they knew that you had made this particular claim. So if you start looking at the Roman maxim on this, they're very clear about it. They say, prae in tempora, potia in jure. And what that means is prior in time is higher in right. Why do we like this temporal division? Well, because it's very clear so that you're going to reduce the kinds of disputes that are going to take place. And you can now do this not only for the first guy and the second guy, but as in the jus tertiae situation, you can say higher in time is prior in right, if in fact you're dealing with a battle between the second and the third party. So what happens is you now develop a system of relative title. And if you do this, then the other guy is going to be perfectly secure against the rest of the world. If you don't do this, then what happens is, if you're dispossessed, you can't recover. There was nothing in there which limited the amount of land that you can take as a matter of positive principle to only that amount of land which you could usefully cultivate and so forth. The Roman rule maxim, prior in time is higher in right, essentially will favor incumbents, i.e., Aboriginal and Native peoples, over the newcomers coming in there, which now creates a genuine kind of tension. One of the things that was done, for example, in John Locke, he gets very kind of obscure on this issue. And it turns out that you acquire possession of an acorn the moment you pick it. You acquire possession of the land the moment you cultivate it, maybe. If you go back and you look at Locke in the 5th chapter of A Property in the Second Treatise of Government, the word occupatio never occurs in that particular chapter, which means that he's bollocks the Roman law and the English common law and has done so in a way with the labor theory of value, which makes him sound sometimes like a libertarian and sometimes like an early precursor of Karl Marx. Why does he do that? Because if you require cultivation and you have a series of Indian tribes who are hunter-gatherers, then their possession doesn't count. And so what you do is you take an ostensible neutral principle of property law and you turn it into a political tool, which is one of the things that I mentioned happened to you. And it turns out that Locke is wrong on the land. You put the word occupatio back in place, meaning it's just a demarcation, and the whole system completely turns over, and there is not a slightest hint of Marxism in the common law or in the Roman law, and there are all sorts of ways in which you could easily and sensibly read it into John Locke. If a guy doesn't get something right, it turns out if he's that influential, the error will span, at this particular point, 3 centuries plus.